of clarified questions before the Legal and Technical Commission considers further the case on possible non-compliance. They do not consider that they are challenging in any way the authority's undoubted power to raise questions in the first place, and nor do they consider that they are feigning ignorance as to what is behind the questions posed by the Commission on 16th March 2026, or seeking for improper reason to delay an inquiry that raises issues of very real importance for all concerned. As Ms. Sander explained yesterday, the applicants could readily infer that the questions of 16th March concerned the application for an exploration license submitted by TMC USA to the US National Oceanic and Atmospheric Administration. While it is precisely because of the importance to the applicants of responding to a case on possible non-compliance that they are seeking a fair opportunity to understand that case and respond before the Commission considers further. By contrast, for the respondent, the applicants are asking the Chamber to micromanage the exercise by the authority of its discretionary powers to address potential non-compliance, and have adopted a litigation strategy that seeks delay for delay's sake, with the only intention being to frustrate the authority in the exercise of its powers, in particular under Article 137, thus undermining the multilateral framework established under Part 11 of UNCLOS. So, two starkly different descriptions, but there are two clear pointers as to which description is more accurate. First, there is a simple but very important pointer when one examines the timeline. This will shortly be developed by Ms. Sander. But the basic point is that the applications and the current requests were lodged only in circumstances where the authority was failing both to provide the requested clarifications and to extend the deadline of 31st May for the responses. This was not a case of the applicants seeking indefinitely to put off an important inquiry, but rather of two contractors wishing to have a reasonable opportunity to understand and address questions of obvious importance before the Commission continued in its consideration. If, as was being suggested yesterday by the respondent, this was all about a very preliminary stage in an inquiry that may be a very long process, why not allow for the step of clarification, followed by a reasonable period for the responses, and only then go forward with the consideration? Why was it so difficult to provide for a temporary delay to the next stage of the inquiry, or at least to signal that there could be such a delay? Second, there's the applicant's proposal of 19th June, about which you heard almost nothing yesterday from the respondent. You will recall that this is at tab 1 of the judge's folder of yesterday, with the key elements of the proposal at page 2, paragraph 8. It is a very important document, and we ask you to read it carefully again when you deliberate. Its importance derives in part from the fact that it was sent after the indication of the relief sought in the request for provisional measures, and was sent with a view to avoiding altogether the need for provisional measures. The Chamber will recall the three limbs. First, the provision of further particulars so that NORI and TOML could respond meaningfully to the questions posed in the 16 March 2026 letter. Second, the extension of the 31st May deadline. And third, the deferral of consideration by the Commission and Council to a subsequent session. What is there about this proposal that suggests that the applicants are in fact engaged in a bad faith strategy to delay indefinitely consideration by the authority of possible non-compliance? With respect, there is nothing, absolutely nothing. The true position is that the applicants were simply seeking temporarily to defer consideration by the Commission of the possible non-compliance issue until they had had a time to put in a meaningful response by reference to clarified questions. This is not litigation strategy. This is not an attempt to undermine the authority's very important powers under Article 137. It is an attempt by the applicants to agree with the authority on the short-term pause needed for the failure to afford due process to be addressed in a simple and obvious way. Instead of focusing on this bona fide and pragmatic attempt to avert the need for a provisional measures hearing altogether, and possibly even to resolve the issues in dispute, the respondent focused yesterday on the suspension that has been sought as one aspect of the relief in the provisional measures request, characterising this as calling for the complete cessation of any consideration of the applicant's conduct and an enforced silence on the part of the authority. But the applicants confirm that their real concern is to avoid final recommendations or conclusions being reached on the issue of possible non-compliance without the applicants being afforded due process. If it had been otherwise, the proposal of 19th June would have been formulated very differently. As one last point before handing over to Ms. Sander to respond on the key facts, the respondent alleged yesterday on several occasions that the applicants have embarked on a classically aggressive litigation strategy aimed at deflection and evasion, with attack being deployed as the best means of defence. That is not a fair characterisation. In the letters of 21st and 22nd April, the applicants suggested a period of 17 days for the respondents to provide clarifications, but that is precisely because they were subject to the deadline imposed by the authority of 31st May for their responses. The applicants only then lodged the application and the requests on 30th May because the authority had refused to extend the deadline. And all the signs were that the authority planned to address and likely reach conclusions on the possible non-compliance issue in the current session. To recall, in its 19th March 2026 decision, the Council had made clear that it was awaiting the Commission's report on the issue during the second part of its 31st session, that is, the session that is about to begin. And one might ask, how should one characterise the approach of the respondent in this matter? Insisting on the deadline of 31st May, Failing to agree to the consultations proposed at paragraphs 20 to 23 of the Notice of Dispute, that is, consultations before the 31st May deadline, failing to engage constructively with the applicant's proposal of 19th June, conditioning any subsequent consultations on the applicant's withdrawing the provisional measures requests, as opposed to suggesting a stay, opposing Nauru's participation in these proceedings, challenging the manifestly reasonable direction of the Chamber under Article 90, paragraph 4, and characterising this in oral submissions as frankly troubling. Providing a non-response to the applicant's letter of 1st July and electing to deal with the issue of automatic extension of the NORI exploration contract only in its second round, so that the applicants are denied an opportunity to respond at this hearing on what is a very important issue indeed. Making repeated in terrorem arguments yesterday that threatened extreme repercussions, instead of dealing with the details on the narrow issue of due process rights with which this hearing is truly concerned. Perhaps the Chamber might conclude that it is not the applicants who have been aggressive in their approach. On a more practical note, given that the respondent will only be addressing in its second round the question of its position on paragraph 16 of the Council's procedures and criteria for extension, the applicants may need an opportunity to submit brief responsive submissions in writing, and we respectfully draw this to your attention. That, of course, depends on what is said. But it may be that, as I foreshadowed yesterday, the applicants will wish to seek an additional provisional measure in this respect. And given the imminence of the expiry of the 22nd July expiry date, possibly also a further request under Article 90, paragraph 4. That, of course, would be done over the next few days. Mr. President, members of the Chamber, Ms. Sander will now respond on the key issue of facts. Mr. Ochi will then return to the issue of prima facie jurisdiction, and I will respond on the limited issues raised on plausibility and the other elements of the test for the order of provisional measures. Mr. Eastwood will then conclude. Thank you, Mr. President, members of the Chamber, and may I now ask you, Mr. President, to call Ms. Sander to the podium.
I thank you, Mr. Wordsworth. I now give the floor to Ms. Sanders. Madam, you have the floor.
Mr. President, members of the Chamber, it was said by the respondent yesterday that the applicants had presented a tiny part of the story and been silent on certain matters. It's therefore important to recall the events that are in fact relevant for the purposes of these provisional measures proceedings, and which the applicants did address before the Chamber yesterday. As to the legal framework, it's clear that the two overarching points I identified yesterday morning are common ground. First, that the Council and Commission have a central and important role with respect to monitoring and evaluating a contractor's risk of non-compliance with their obligations. Second, that in discharging this role with respect to the current inquiry, due process must be adhered to at every stage. The Chamber has seen the Council March 2026 decision, which expressly states this. As to the relevance of the 2024 procedure in this respect, the respondent continues to seek to dismiss it, describing it yesterday as a red herring. But it does not explain why the procedure was then expressly referred to in the respondent's cover letter, transmitting the 19 March questions to the applicants. I took the Chamber to that cover letter yesterday, and it's at tabs 8 and 9 of the judge's folder. The respondent twice took you to a 3-stage flowchart at Appendix 1 of the procedure, asserting this is not directly the procedure by which the March questions were put to the applicants. But that is not the applicant's case. As the applicants took some care to explain yesterday, the relevance of the 2024 procedure for present purposes is that it reflects a broad recognition of the importance of due process requirements when engaging with the contractor with respect to a risk of non-compliance, emphasising the central tenets of transparency and eliciting a positive response. Which part of that does the respondent say does not apply equally to the present inquiry? Turning to the facts, the 3 questions transmitted to the applicants on 16 March 2026 are of central importance. The applicants have at no point denied the right of the Commission to ask those questions, reflecting its central role to which I referred earlier. But to indicate that the only thing that happened is a series of questions is to indeed only tell a tiny part of the story. It's important to first recall what occurred prior to 16 March, as these aspects were only referred to briefly by the respondent, but provide important context informing why the applicant sought further clarification with respect to the March 16 questions. There was the license application of TMC USA to the US authorities in July 2025, a fact which the applicants have not shied away from, notwithstanding the impression that the respondent sought to give yesterday. In the subsequent Secretary-General Circular of 15 January 2026, the respondent requested information from all 21 contractors regarding, I quote, any information related to the contractor or other relevant third parties where possible non-compliance may arise out of direct or indirect activities in the area, including contractual obligations to act in accordance with the multilateral legal framework established by the Convention and the Agreement. Now, of course, as the applicants expressly acknowledged yesterday, they well understood that the broader context of the question was the TMC USA application. And with that understanding, the applicants responded by the set deadline in February, stating that there were no incidents, activities, or events that might place the applicants themselves at risk of non-compliance with their contractual obligations. So against that backdrop, when on 16 March the Commission then sent further questions to the applicants alone with respect to direct or indirect activities in the area, it was evident that the Commission did not accept the applicants' position. But the applicants did not and still do not understand specifically why or on what basis the Commission did not accept the applicants' position. The applicants couldn't seek to garner that understanding from any engagement with the respondent prior to their identification some 10 days earlier as being at risk of non-compliance in the 6 March Commission report, because apart from the 15th of January circular, there was none. No prior notification, consultation, or information as to the reason for the applicant's designation beyond the Commission's reference to unilateral regimes and to possible non-compliance with obligations to act in accordance with the multilateral legal framework. So turning to the March 2026 questions, To repeat, it is not the fact that the Commission asks the questions that is at issue. Rather, it is the confusions and uncertainties that arise with respect to those questions and the applicant's right to know the case being put to them. As I noted yesterday, the Commission itself has recognised that the question of conduct outside the multilateral legal framework established by the Convention gives rise to what it has described as unprecedented legal questions, including specifically in relation to contractors. The Chamber will recall that I spent some time yesterday morning considering each of the three questions in turn, explaining that whilst the applicants entirely accept that certain inferences can be drawn from the general framing of the questions, it was reasonable and understandable for the applicants to consider that the Commission's case against them could take several forms, depending on the nature and extent of the specific concerns, the respondent's position on various legal issues, and the factual basis for those concerns. Professor Sand stated that the applicants had chosen yesterday not to share with the Chamber certain details relevant to the understanding of the questions. But of course, the Chamber will have heard that the applicants expressly referred in its oral opening to both the TMC USA's application to the US authorities and to the relevant corporate structure. More specifically, in relation to question 2, an example of one of the confusions and uncertainties given concerned what the Commission meant when it asks about a contractor indirectly undertaking an activity, and whether the Commission suggested that the conduct of a separate juridical person that's related to a contractor in the sense that it forms part of the overall group of companies somehow automatically amounts to the indirect conduct of the contractor. And as I explained yesterday, this question arises precisely because the two applicants in TMC USA are three separate companies within the TMC group. Neither applicant is a parent company or a subsidiary of TMC USA. And there are no common directors as between either applicant and TMC USA. Well, yesterday we heard from the respondent that the idea that they're separate companies is a fiction. If it is indeed the Commission's position that the questions posed are predicated on a piercing of the corporate veil, that's precisely the type of clarification that could usefully be provided to the applicants so that they could then provide a meaningful response, although the applicants still do not know the basis on which the Commission considers it appropriate to pierce the veil. It's difficult to see how the Chamber is assisted by the respondent asserting yesterday, incorrectly, that the applicants had said nothing about Article 137 of UNCLOS, that there had been total silence. In fact, in the course of the applicant's careful consideration of the three questions yesterday morning, Article 137 was referred to several times. And this included the applicant's recognition that an inference that they were able to draw in relation to the first question was that by its reference to appropriation of part of the area or of its resources, the Commission appears to be focused on Article 137 of UNCLOS, on the legal status of the area and its resources. Indeed, it is the applicant's considered engagement with Article 137 that informs some of the confusions and uncertainties that then arise. So, with respect to whether the applicants may contribute to appropriation for the purposes of question 1, it was explained yesterday that it wasn't clear whether it might be being suggested that as a matter of interpretation of Article 137, the applicants are under a positive duty not to recognise any rights conferred on TMC USA by the US authorities. That now appeared to be Professor Sand's focus. And if that reflects the respondent's position, why could that position not have been spelled out back in April or in response to any of the other requests for clarification from the applicants? Relatedly, it's also not clear whether the Commission is concerned with a risk of contribution to appropriation by TMC USA or the USA, and the Chamber will recall that the more specific uncertainties I identified that arise in either context under subpara 1 of Article 137. The impression given yesterday is that the applicants were engaging in improper delay tactics by seeking clarification and further information. The Chamber was told that the Commission was only seeking relevant information, no more and no less. However, as recognised in the 2024 procedure, a risk of non-compliance may have important consequences. And as recalled yesterday, if the applicant sought to respond without fully understanding the Commission's concerns, there's every chance that the applicant's responses would not address the Commission's unarticulated specific concerns. And in turn, there's a real risk that the Commission might conclude that the applicants have failed or even refused to engage meaningfully, with the ensuing risk as to how that informs the recommendations the Commission intends to make with respect to compliance. And in instances of non-compliance, the Council has the power to issue punitive measures, which is why the due process requirements are so important. All parties yesterday referred to paragraph 4 of the 26 March 2026 decision, featuring the Council's instruction to the Commission to continue to ensure due process, transparency and fairness at every stage in the conduct of this inquiry, including by providing contractors and sponsoring states with the right to respond. The respondent relied upon the Council's support for the Commission inquiry in this respect, indicating that the words "continue to" implied Council support for the 3 questions as postulated by the Commission 10 days earlier. Well, fine, but that's no answer to the point that adherence to due process demands that, having posed those questions, if the applicants entirely reasonably and understandably ask for further clarification so as to understand the case against them, they're entitled to that clarification consistent with the central tenets of transparency and eliciting positive responses that the authority itself has recognised are of such importance. It was in their letters of 21st and 22nd April, respectively, that the applicant sought that further clarification. The respondent yesterday made 2 points on those letters. First, that it set out wide and varied demands, which it characterised as a deluge of defensiveness. And secondly, that it imposed an 8 May deadline on the respondent to respond, despite the fact the Commission was not in session. 3 points in response. First, paragraph 3 of the April letters made clear the crux of what the applicant sought: confirmation of the procedure that the Commission intends to follow, and further clarification in particulars in respect of the questions raised and their legal basis, so that the applicants may provide a complete and informed substantive response. So that is, in essence, a request that due process be adhered to. Second, what is crucial to appreciate is that the Commission had chosen to impose the deadline of 31st May on the applicants to respond to the 3 questions. So the fact that here in April the applicants are proposing a deadline of 8th May for the respondents' response demonstrates how seriously they were seeking to be in a position to then respond by the 31st of May deadline. Third, as to the respondent's complaint regarding the Commission not being in session at this time, so unable to respond by 8th of May, the applicants are still not clear why it would not at least have been possible to explore the option of the well-established modality for informative exchanges to increase understanding between the parties. The respondent reiterated its position yesterday afternoon that these are not comparable to the demands and the work the applicants were asking the Commission to carry out. Well, this sits awkwardly with the respondent's stance, repeated yesterday, that the questions are straightforward. There's also a silence procedure available with respect to Commission decision-making, intended to be used in situations that are time-sensitive and where not all members of the Commission are able to attend. But further, and in any event, critically, this time crunch for providing further information to the applicants was of the respondents' own making. It chose to impose and maintain the 31st of May deadline. And if it had released that pressure valve, a sensible procedural timetable could have been agreed. As to why the respondent maintained the 31st May deadline, it's instructive to recall that the evidence indicates the Commission planned to push forward with its report at the current session. The Commission had stated in its 6 March report that it will report to the Council on this issue, that is the inquiry into the applicants, during the second part of its 31st session. And the Council had expressly stated in its March 2026 decision that it awaits the Commission's reports and recommendations with respect to the inquiry. And this 31st May deadline is important context to the 2 May letters in which the respondent responded to the applicant's request for further information. These 2 letters were presented yesterday as sufficient to allay the applicant's concern, so I'll take each in turn. As to the 30 May letter, yesterday the respondent drew the Chamber's attention to the penultimate paragraph, in which the Commission Chair reiterated the Commission's full commitment to the discharge of its responsibilities in accordance with its mandate and established procedures. But from the applicant's perspective, it's the third and penultimate paragraph that have more acute pragmatic significance. There, the Commission Chair did not express any position on the matters raised by the applicants. So not providing any clarification or any assurance as to whether and when it would be provided, or more generally proposing a pragmatic procedural timetable. The reason given was because the Commission was not in session until 29th of June. Yet in the final paragraph, the Chair reiterated the 31st of May deadline. So what were the applicants to do? No doubt the respondent's answer would be, well, answer the questions. But as I explained in detail yesterday, it was entirely reasonable and understandable for the applicants to consider that they did not understand the case being put to them, and they therefore were unable to provide a meaningful response. And as I recalled earlier, the consequences when being assessed for possible non-compliance are potentially hugely significant. So at this point, the applicants find themselves boxed in with a fast approaching 31st of May deadline and no clear procedural timetable in place. This is the context for issuing the notification of dispute on 18th May. And a key aspect and objective of this notification was in fact seeking an amicable solution. The applicants expressly requested consultations with a view to resolving the dispute in an expeditious and amicable manner. The applicants, and I quote, reaffirmed that it has at all times been willing to engage substantively with the Commission's inquiry and remain so, reiterating that until the authority discloses the factual and legal basis of the inquiry and confirms the applicable procedural framework, the applicants are unable to respond substantively without risk of prejudice to its own position. As to the respondent's response on 26 May, there are 3 key points for present purposes. First, as I indicated yesterday, the respondent's acknowledgement in that letter that a thorough legal assessment was required with respect to the issues presented by the applicant's request for further information is difficult to reconcile with the respondent's current stance that the three questions are straightforward. Second, the letter stated that the Commission is currently evaluating your request to determine how they may be accommodated. It's not understood how the Commission could currently be doing so, as the respondent has been adamant that it was not possible for the Commission to convene before the commencement on 29th of June. But in any event, this did not give the applicants any comfort that their request would be accommodated. And third, and critically, there's no withdrawal of the 31st of May deadline, which remained in place. So, as Mr. Wordsworth indicated this morning, the applicants and the current request were lodged on 30 May only in circumstances where the authority was not providing clarifications and refused to extend the deadline of 31st May. There are two aspects to draw out from the unfolding of events after the filing of the present request. The first is the clear urgency with respect to the applicant's situation. Yesterday, the respondent sought to minimise this, accusing the applicants of concocting urgency out of thin air, noting the inquiry process had no fixed time frame. But as the applicants explained yesterday, this is the point. There is no fixed time frame. The applicants simply do not know what the Commission or Council will do, including whether, and if so, how and when, as the necessary first step, the required information and clarifications would be provided, because they haven't been told how the process should unfold. And that stands in contrast to what I set out yesterday, that what the applicants do know, notably that the respondent now considers the applicants as having steadfastly refused to provide any substantive response. The Council awaits the Commission recommendation. There's a possibility of a third part to the session being held. And in any event, the Commission may meet as required, including by way of an emergency session. The second and telling aspect is the continued efforts of the applicants to seek a pragmatic and reasonable solution that would avoid the need for the present proceedings. Mr. Wordsworth took you yesterday to the letters that the applicants sent on 19 and 23rd of June, respectively. So far from evidencing a sharp-elbowed litigant, they show two contractors trying to find a solution which would ensure, on the one hand, the applicant's due process rights are protected, and on the other hand, the authority could receive meaningful and positive substantive responses to the questions it had raised. Mr. President, members of the Chamber, the crux of the present request concerns due process, and the timeline of the relevant events clearly demonstrates that the applicant's description of that request, as outlined by Mr. Wordsworth, is the correct one. I thank you for your kind attention, and I invite you to call Mr. Oki to the podium.
You have the floor, sir.
Mr. President, members of the Chamber, I will respond to the respondent's case on prima facie jurisdiction, addressing the same three issues as in opening and taking these in the same order. So first, the crystallisation of the dispute, second, Article 187, paragraph C, and third, Article 189. I turn to the first part of my submissions. The Chamber will recall that yesterday I took you through 5 exchanges between the parties in 2026, which demonstrated that a dispute concerning the applicable requirements of due process and whether the authority had complied with those requirements had crystallised by the 18th of May 2026 or at the latest, 26th of May. Those documents evidence that the respondent was fully aware that the parties' views on these questions were positively opposed. The respondent's submissions on prima facie jurisdiction did not engage with any of these documents, or indeed with the argument that the parties' views were positively opposed and a dispute concerning due process had crystallized. Since the documents show a positive opposition of views, and that is all that is required at this stage, that should be the end of the matter. Nevertheless, the respondent still appeared to deny this, because yesterday it repeated the assertion that the applications and requests are wholly premature. The only reason given was that the Commission's inquiry is still at an early information gathering stage, and in this connection the respondent repeated that the identification of the applicants as requiring specific attention as to possible non-compliance is nothing more than a preliminary finding. The respondent's position appears to be that a dispute related to due process with respect to a compliance inquiry, or at least an inquiry pursuant to paragraphs 9 and 10 of the Council's June 2025 decision, can crystallize only where there has been a finding of actual non-compliance. But, as I explained yesterday, the preliminary nature of the finding of potential non-compliance in no way disproves the existence of the dispute concerning due process, including whether due process was afforded at the preliminary stages of the inquiry, resulting in that preliminary finding. Now, whilst the Chamber already has this point, and it is common ground between the parties, it is necessary to recall once again that the Council expressly instructed the Commission to ensure due process at every stage of the inquiry. The respondent's point appears to be that when assessing whether due process has in fact been accorded, one should look at the entirety of the Commission's inquiry process, which the respondent now says may be very long. But that is an argument on the merits. The respondent's assertion that due process will be afforded in the future stages of an inquiry cannot somehow preclude or eradicate the existence of a dispute, that is, the existence of positively opposed views as to what due process requires and whether it has been afforded to date. I turn to the second part of my submissions. The Chamber clearly has prima facie jurisdiction pursuant to Article 187, paragraph C. As regards subparagraph 1, the respondent stated that there can be no dispute concerning the interpretation or application of the contract because any assertion that Section 13(4) has been breached is unarguable. Moreover, the respondent asserted that this issue has fallen away because we made it clear in our submissions of yesterday that the applicants do not allege bad faith. The respondent does not engage with the applicant's case. Yesterday, I explained that the respondent's obligation to afford fundamental due process throughout its inquiry is an element of its obligation under Section 13(4). Put another way, Section 13(4) is a source of the applicant's right to due process, a point that Mr. Wordsworth made yesterday, as to which, quite correctly, the respondent has taken no issue. In this respect, the dispute concerns the interpretation and application of Section 13(4). That is not the same as an allegation of bad faith in breach of Section 13(4), And it was for this reason that I explained yesterday that it is not necessary for the applicants to allege bad faith. No allegation of bad faith was advanced in the applications of 30th of May. There has been no concession, and Professor Sands was quite wrong to suggest otherwise. As regards subparagraph 2 of Article 187, paragraph C, the respondent continues to assert that the acts or omissions of the authority at issue do not relate to activities in the area. Reference was made to the definition of activities in Article 1, paragraph 3 of the Convention, but this sheds no light on the critical issue of the meaning of the words relate to in subparagraph 2. The respondent asserted that because it arises out of an exercise of the authority's compliance powers, the dispute does not address activities as defined in the Convention. But this is nothing more than a repackaging of an unsupported assertion that the words relates to can mean only directly relates to. And there was no response to the submission of yesterday that the words relate to are to be given their ordinary broad meaning, which does not require any reading in of a requirement of directness. Further, the respondent did not engage with the obvious point that the dispute arises out of a compliance inquiry, which is itself said to relate directly and only to activities in the area. Moreover, there was also no response to the question as to whether, on the respondent's position, any dispute arising out of any assessment of a contractor's compliance with any contractual obligation could ever relate to activities in the area. I turn to the third part of my submissions, Article 189. The Chamber will recall that yesterday we addressed Article 189, explaining the applicant's interpretation and why the Chamber's jurisdiction over the present dispute is not excluded by any part of Article 189. There are two preliminary points. First, yesterday, the respondent sought to criticise the applicants for not responding to the respondent's position under Article 189 in their applications of the 30th of May, and only belatedly addressing that argument yesterday. This is a non-point. The first time that Article 189 was raised was in the respondent's statement of the 25th of June, shortly before the hearing. The applicants then addressed the matter, and the Chamber will recall that we did so in some detail in the first round oral submissions of yesterday. Since the applicants did not consider Article 189 to exclude the Chamber's jurisdiction, there was no need to address it in the applications themselves. Second, and also in relation to timing, as the Chamber will recall, yesterday Professor Sands stated that he intended to respond to at least some of our submissions on prima facie jurisdiction only during the respondent's second round oral submissions. But any such response can now only come after the applicant's oral submissions have concluded. I've therefore tried my best to understand what Professor Sands meant when he said that he would, quote, come back tomorrow to some of the articles that have been submitted on Article 189. However, this has been a genuine puzzle, given that Article 189 comprises a single paragraph, and I cited no academic commentary. Perhaps this was a reference to the travaux to which we took the Chamber yesterday, but if so, there is no indication of what the respondent might say about that. Or perhaps the reference was to the latter part of Article 189, about which the respondent said very little yesterday, whilst also appearing to suggest in this context that our submissions amounted to much smoke and mirrors. This leaves us in the difficult position of having to guess at the respondent's case on Article 189 and at a risk of being unable to respond meaningfully now to any new point the respondent wishes to make this afternoon. In these circumstances, insofar as the respondent does make use of its closing statement to advance new points, the applicants must of course be afforded an opportunity to respond briefly in writing. In any event, the respondent's big point was tolerably clear. This was the assertion that the applicants have come before this chamber to dispute the authority's exercise of its discretionary compliance powers to ask questions and to frame its questions as it sees fit. On this basis, the respondent asked, rhetorically, whether the members of this chamber each wish to allocate to themselves the role of deciding on a measure under Part 11 to ensure compliance. But this is not the applicant's position, and moreover, the respondent's straw man argument does not engage with the applicant's actual position. There are 3 points. First, there was no response to the submission that due process itself is not a matter of discretion, such that it can be disapplied or disregarded by the authority at will when exercising its compliance powers. That is a point of obvious importance in this context, and it is difficult to see how it could be countered. Contrary to Professor Sand's suggestion, this is not just a lot of noise. Second, the applicants are not asking the chamber to put on the shoes of the authority and ask how its compliance powers should have been exercised. The applicants merely ask the chamber to exercise its responsibility to review matters related to due process. Professor Sands correctly accepted that the authority is not immune to judicial review by this chamber. To draw an analogy, judicial review as a matter of English domestic law focuses on the lawfulness of the decision-making process as opposed to the merits. And a classic ground for judicial review is the failure to comply with due process and procedural fairness. For this chamber to exercise its powers of judicial review in relation to such disputes would not, contrary to Professor Sand's suggestion, entail any departure from the judicial function. The respondent did not dispute that the present dispute is correctly characterized as primarily contractual and administrative in nature, nor did the respondent have anything to say about the travaux I took you to, which recorded a clear intention that the chamber should have jurisdiction over such disputes. At this juncture, I should note that it was suggested on various occasions by the respondent yesterday that any order of provisional measures by the chamber in this case would have serious and adverse consequences so far as concerns the long-term ability of the authority to fulfill its compliance functions and even undermine the rule of law. But that is wrong. And that is clear from the statement of the chairman of the first committee during the 6th session, which recognized that disputes concerning infringement of fundamental rules of procedure may arise amongst contractors and the authority, and stated that juridical safeguards for adjudication of disputes arising from a contract or an administrative decision are essential to proper administration. Juridical safeguards strengthen, not weaken, the integrity of the process at issue in this case. Third, yesterday I explained that the applicant's understanding is that the respondent's objection focuses on the first sentence of Article 189, which specifically concerns the exercise of the authority's discretionary powers. This was confirmed by what we heard yesterday, since the respondent said little about the rest of the provision. The only point was an assertion, again, that any issue under the exception in Article 189 concerning conflict with an obligation under the contract, in this case an obligation to afford due process, has fallen away because the applicants make no allegation of bad faith in breach of Section 13(4) of the contract. And as I have already explained, this does not engage with the applicant's actual case. Before I conclude, I should note that since the respondent has not yet responded to the question whether it will treat NORI's contract as expired with effect from the 22nd of July, I am unable to add anything to our submissions of yesterday in relation to this issue. Mr. President, members of the Chamber, thank you. Mr. President, may I ask that you call Mr. Wordsworth to the podium?
Thank you very much, sir. I now give the floor to Mr. Wordsworth. Mr. Wordsworth, you have the floor, sir.
Thank you very much, Mr. President. Mr. President, members of the Chamber, I respond on plausibility of rights and the real and imminent risk of irreparable prejudice. On plausibility of rights, there is no issue as to the existence of the relevant right, that is, the right to due process. No issue was taken with any of the points that I made yesterday as to the nature and source of that right. And it was not contested that, consistent with the Council's decision of 19th March 2026, the applicants have a right to due process, transparency and fairness at every stage in the conduct of this inquiry. Professor Sand's argument was that the applicants have no plausible rights because there is no plausible argument that the rights to due process have been violated or could have been violated. He did not point to any authority to make good the respondent's position that there is a test on arguable or colourable breach to be satisfied at the provisional measures phase, which is unsurprising because international courts and tribunals do not wish for hearings on provisional measures to turn into dress rehearsals for the merits. There was reference to Gambia and Myanmar and to the separate opinion of Judge Nolter to the ICJ's provisional measures order in South Africa and Israel. But these are cases on the Genocide Convention, and there is a very particular issue of the identification of plausible rights in a context where genocidal intent is a requirement for any breach of the Convention. As Judge Nolter explained, given the crucial role of genocidal intent for rights under the Genocide Convention, and for the distinction between genocidal acts and other criminal acts, the plausibility of this mental element is, in my view, indispensable at the provisional measures stage of proceedings involving allegations of genocide. It was Judge Nolter's view that there is a lack of clarity over what plausibility requires, and that the recent jurisprudence suggests that some level of evidence supporting the allegations must be provided. But he did not say that the party requesting provisional measures must establish a plausible case on breach. And as is very well known, the former president of the International Court of Justice, Judge Donoghue, has explained that the finding of plausible rights in the South Africa and Israel case was not to be equated with a plausible case on genocide. The tribunal's order on the Libertad, to which Professor Sands referred, also does not set out a requirement for the existence of a colourable breach. But as we said yesterday, even if there were such a requirement, it is met on the facts of the current case. and this applies all the more so with respect to the view of Judge Nolte on the need for some level of evidence supporting the allegations. I'll not repeat the facts that Ms. Sander has just gone through again, but to characterise as nonsensical the applicant's position on failure to accord due process merely denotes an unwillingness to engage with the details of what the applicants are actually saying and the documents upon which they rely. On real and imminent risk of irreparable prejudice, the respondent again did not engage with the details of what the applicants are actually saying. 3 points were made. First, it was said that no steps have been taken which could be said to affect the applicant's rights in any way at all, and that the only material step had been taken to request information from the applicants in a private letter. That, however, is to ignore altogether the deadline of 31st May imposed by the respondent and all the indications that there were plans to advance materially in the inquiry very shortly after 31st May, and seemingly even to make and submit a recommendation to the Council in the July 2026 session. As we have noted, in its 19th March 2026 decision, the Council had made clear that it was awaiting the Commission's report at the July session. It was repeated that the applicant's case is based simply on presumption, and Ms. Sander has just recalled, concocted out of thin air. But that again is to ignore the details and what the documents actually show. It is one thing to say in general terms that the applicants will be afforded due process, but the actual acts of the authority showed that the issue of possible non-compliance was going to be considered at the July session without the applicants being able to submit meaningful responses to the questions that have been posed by the Commission. Further, when the applicants submitted their proposal on 19th June, the respondent declined to agree to defer consideration of the matter to enable the applicants to submit their meaningful responses. As part of this argument, the respondent emphasised that there is no fixed timetable for the inquiry and nothing to support the applicant's assumption that the Commission will complete its inquiry at the July session or do anything without affording the applicants due process. And that is to ignore our point of yesterday, repeated by Ms. Sander just now, that the absence of a fixed timetable at best added to the uncertainty, in particular where there were indeed strong indications that a recommendation would be made during the July session. Second, there was a point on the extension of the NORI exploration contract. It was said that this issue of extension is completely separate to the question of non-compliance, and that there is no evidence to indicate otherwise. I dealt with that point yesterday, and there was no engagement with our position that the suggestion of complete separation stretches credulity. And as the Chamber will recall, the respondent has publicly stated that it will regard a finding of non-compliance arising from a contractor's unilateral departure from the ISA regime as constituting a serious breach of the trust and legal obligations underpinning its relationship with the ISA, which may affect the contractor's credibility and compliance record across various contexts, including the assessment of future applications. Third, it was said with respect to irreparable prejudice that there could be no harm caused by the implicit identification of the applicants in the 6th March 2026 Commission report, and that any prejudice caused to contractual rights and activities would be necessarily revenue-based and therefore not irreparable. Plainly, the identification issue is not central at this stage, and we did not suggest otherwise yesterday. As to the prejudice being merely to a source of revenue, there was no engagement with our basic point that the prejudice is to the right to due process and the integrity of these proceedings with respect to the Chamber's ability to issue meaningful final relief requiring the authority to afford due process. Finally, it was said yesterday that the applicants had passed in complete silence on the impact of any measure on the functioning of the respondent and the rights of the respondent. That, of course, is not correct, and I refer you to the transcript of yesterday morning. The basic argument made by Professor Sands was that the measures sought in the applicant's requests would be intrusive and highly prejudicial to the ability of the respondent to exercise its compliance functions under the Convention, such that they might well have been designed for that purpose. That is to suggest a bad faith motive on the part of the applicants, and there is no basis whatsoever for that. And as I have already noted, the applicant's real concern is to ensure that no final recommendations or conclusions are reached on the issue of non-compliance without the applicants being afforded due process, such that any final relief ordered by the Chamber on the applications is not rendered illusory. That might cause delay, but could not prejudice the respondent, and indeed Professor Sands was suggesting yesterday that the process may in any event be a very long one. Mr. President, members of the Chamber, thank you for your attention. I ask you to call Mr. Eastwood to the podium, who will conclude.
Thank you, sir. I understand that the agent of the applicants, Mr. Eastwood, will make closing remarks and present the final submission of the applicants. In this regard, I wish to recall that pursuant to Article 75, Para 2, the rules of the Tribunal, at the conclusion of the last statement made by a party at the hearing, its agent, without recapitulation of their arguments, shall read that party's final submissions. A copy of the written text of these, signed by the agent, shall be communicated to the Chamber and transmitted to the other party. I now invite the agent to take the floor to make the closing statement and present final submissions. You have the floor, sir.
Thank you, Mr. President, members of the Chamber. I would like to conclude the second round of the applicant's submissions by returning to the applicants themselves. Over the course of these proceedings, much has been said about the legal frameworks, institutional competencies, procedural requirements, and the conduct of the inquiry. But it is important, if not critical, not to lose sight of who NORI and TOML are. These are not contractors who regard their obligations as an inconvenience. They are not entities seeking to avoid oversight. They are not entities looking for ways to frustrate the competence of the authority. To the contrary, for more than a decade, NORI and TOML have undertaken their obligations under their exploration contracts, under ITLOS, and under the applicable legal framework with the utmost seriousness. NORI was the first commercial entity to secure an exploration contract, the first to be sponsored by a developing state, turning Arvid Pardo's vision into a reality, a system that has been duplicated now by all subsequent developing states, demonstrating that the only way for a developing state to participate in activities in the area is with a commercial partner. The applicants have invested substantial resources in conducting exploration activities in the area, frequently at the forefront of the ISA regulatory regime. NORI was the first contractor to undertake a fully integrated test mining program and the first to prepare an environmental impact statement, or EIS, for such activities. This review and approval of that EIS required the Commission to address novel regulatory issues, and notably, for the purposes of these proceedings, was undertaken through the Commission's silence procedure rather than at an in-person meeting of the Commission. This provides a further example of the Commission taking decisions outside its formal sessions in order to address substantive matters. The reference for that decision is ISBA/27/C/16/add2. The applicants have participated actively in the authority's processes. They have generated and shared significant scientific information and environmental data. I made that point yesterday, and there was no comeback on that because there could not be. Their record demonstrates sustained engagement with and commitment to the multilateral system established by the Convention. That commitment, Mr. President and members of the Chamber, has not changed, and that is precisely why they are here. Mr. President, members of the Chamber, as Mr. Wordsworth has just noted, Respondents' Council repeatedly suggested that these applications form part of a strategy of deliberate or strategic litigation. With respect, that submission bears little resemblance to the reality faced by the applicants. The applicants were informed that they had been identified as requiring specific attention in relation to possible non-compliance. That is a serious matter. Any responsible contractor placed in that position would want to understand why. Any responsible contractor would want to understand the factual and legal basis for that identification. And any responsible regulator should expect those questions to be asked and be prepared to respond. The requests for further particulars were not tactical. They were not designed to overwhelm the authority. They were not intended to create impossible burdens or to manufacture complexity. They reflected genuine concerns arising from a serious regulatory designation. The applicants simply wanted to understand the case they were being asked to answer. Mr. President, members of the Chamber, the respondent devoted considerable time yesterday to TMC USA's application to NOAA, as though some hidden motive by the applicants had been uncovered. With respect, that NOAA application is not an application made by the applicants. Contrary to the respondent's suggestion that it is a fiction to believe NORI, TOML and TMC USA are not one in the same, the US NOAA applications were made by a separate legal entity, and NORI and TOML neither controlled that application nor controlled what information was disclosed in connection with it. The respondent repeatedly sought to blur that distinction, but the separate legal personality of affiliated companies is a basic feature of corporate law, not a technicality to be brushed aside when convenient. If the authority considered that those public materials gave rise to a myriad of specific compliance concerns cited by the respondent yesterday, why didn't the authority cite those specific examples as it does with other concerns of non-compliance? For example, the specific and precise question posed to TOML that the applicant showed to the Chamber yesterday. The applicants were entitled to be told what those concerns were and why. It is truly puzzling to the applicants why the respondent was able to articulate these concerns with far greater specificity before the Chamber yesterday, yet was unable or unwilling to do so in its correspondence with the applicants. One possible explanation is that when NORI and TOML were first identified as requiring specific attention in relation to possible non-compliance, the factual and legal basis for that identification had not been established or formulated by the Commission to the extent necessary to pose questions of reasonable clarity. If that were so, it would only reinforce the applicant's concern that they were being asked to respond to an allegation the basis of which had not been adequately defined. Closely connected to that was another straightforward question. The applicants wanted to understand the process. What would happen next? How would the inquiry proceed? What procedural safeguards would apply? What opportunity would be provided to understand and respond to the authority's concerns before findings, recommendations, or other conclusions were reached? Those are not extraordinary requests. They are not a deliberate or strategic litigation strategy. They are ordinary questions that any regulated party would ask when seeking to engage constructively and responsibly in an inquiry. Mr. President, members of the Chamber, there is one aspect of the respondent submissions that I wish to address directly. Over the course of this hearing, the applicants have heard submissions that the Commission allegedly intended to consider potentially affording due process to the applicants during Part 2 of the 31st session. Assuming that submission is true, the difficulty with that submission in light of the current dispute is a simple one. The applicants were never told that the Commission intended to ensure their due process right before or during this forthcoming session. They were never told that their due process rights would be afforded before further steps were taken in this inquiry. They were never told to wait. And most importantly, the deadline for responding to the March questions was never suspended, never deferred, and never meaningfully released pending resolution of those concerns. The opposite occurred. Time and again, the applicants were reminded that the deadline remained in effect. Time and again, they were required to respond. Time and again, the requests for clarification remained unanswered. The applicant's request to attend the Commission's meeting, pursuant to the rules of procedure of the Commission, also unanswered and disregarded. All this while the obligation to respond remained. The applicants can only act on the basis of the information available to them at the time. They cannot act on explanations that emerge later and are presented as facts known to all. They cannot be expected to infer assurances that were never provided. And they cannot be criticised for taking steps to preserve their rights in circumstances where an inquiry was progressing, deadlines for a report remained fixed, and no clear path had been communicated regarding how or when their due process concerns would be addressed. Indeed, one of the striking features of the last 2 days is that the applicants have learned more about the respondents' rationale, timing, intended process, and aspects of the alleged legal basis for the identification than they learned during the entire period leading up to these proceedings. It is also disappointing because it is precisely the type of engagement the applicants have been seeking from the beginning. But it also illustrates the very point the applicants have been making. If those explanations had been provided earlier, openly and transparently, there is every possibility that this dispute would have unfolded very differently. Mr. President, members of the Chamber, Respondents' Counsel also suggested that these applications form part of an effort to undermine or even destroy the multilateral framework governing activities in the area. However, nothing could be further from the truth. The respondent seeks to recast a straightforward request for due process as a broader challenge to the Convention and the multilateral order it establishes. That characterisation is unsupported by the facts and the applicant's position. The applicants ask only that the authority follow its own decisions and their rights respected. The Chamber, we submit, should reject the respondent's attempt to conflate a due process claim with an attack on the Convention itself. NORI and TOML respect the competence and mandate of the International Seabed Authority. They respect the role entrusted to it by Part 11 of the Convention. They respect the institutional value of UNCLOS, and they respect the competence and authority of this Chamber. The applicants are not seeking to undermine institutions. They are relying upon them. The applicants are not seeking to avoid regulation. They are engaging with it. And the applicants are not seeking to circumvent the Convention. They are exercising rights expressly provided by it. Indeed, if the applicants wished to sidestep institutions, they would not be here. The fact that they stand before this Chamber demonstrates confidence in the dispute settlement system established by the Convention itself. Mr. President, members of the Chamber, the applicants want engagement, they want consultation, they want constructive dialogue. They want to understand the concerns that have been raised, and they want an opportunity to respond to them meaningfully. What they do not accept is that such engagement, as requested by the respondent, should be contingent upon surrendering their judicial rights. The Convention provides access to this Chamber for a reason. Parties should not be forced to choose between engaging with a regulator and preserving their legal rights. The applicants seek to do both, and that is why they are here. Not because they wish to litigate, not because they sought delay, not because they wish to frustrate the authorities' work, but because in the circumstances confronting them, they believed it necessary to take steps under the Convention to preserve rights that they genuinely believed were at risk. Mr. President, members of the Chamber, at its beating heart, this case concerns a simple proposition. The applicants do not ask to avoid scrutiny. They do not ask to avoid accountability. They do not ask to place themselves beyond the authorities' reach. They ask only that before serious conclusions are reached concerning their conduct, they are given a fair opportunity to understand the case against them and the right to respond to it. That is not the applicants wishing to undermine or destroy the multilateral framework. That is not strategic litigation. That is due process. And that is why the applicants respectfully maintain their request for provisional measures. The applicants came to this Chamber because they put their trust in the system established by UNCLOS. They came to this Chamber because the Convention expressly entrusts it with the judicial function of resolving disputes under Part 11. They came to this Chamber because they believe in the institutional value of the Convention, the authority, and this Chamber, and because they trust this Chamber to uphold the integrity of that system and to ensure that it operates fairly for all those who participate within it. They trust this Chamber to uphold the integrity of the Convention, to protect the rule of law within the area regime, and to ensure that the system established by UNCLOS operates fairly not only for states and international institutions, but also for the contractors who have chosen to invest, operate, and participate within that framework. Mr. President, members of the Chamber, before I conclude, I must emphasise the matter raised by Mr. Wordsworth. The respondent has elected to address only in its second round submissions the question of its position concerning transitional arrangements pursuant to paragraph 16 of the Council's procedures and criteria for extension in respect of NORI's exploration contract. Given the approaching 22 July expiry date, the applicants reserve their position as to whether any further submissions or any additional request to the Chamber may become necessary in light of what the respondents will say. For the reasons advanced by all four speakers during yesterday's and today's hearings, the applicants submit that the requirements for the indication of provisional measures have been fully satisfied. TOML requests that the Chamber prescribe the following provisional measures. 1. Order the authority to immediately suspend the inquiry regarding the alleged possible non-compliance of TOML with its contractual obligations pending the final decision of the Chamber. 2. Order the authority to refrain from taking, authorising or permitting any further steps or measures in connection with that inquiry pending the final decision of this Chamber. 3. Order the authority to ensure that no recommendations, findings, reports or other outputs arising from the Commission's inquiry are adopted, issued, published, communicated or otherwise relied upon pending the final decision of this Chamber. 4. Pending the final decision of the Chamber, prohibit the authority from taking any action that might aggravate or extend the dispute or prejudice the execution of any decision the Chamber may render. And 5. Order such other provisional measures as the Chamber considers necessary to preserve TOML's rights and to ensure the effectiveness of its eventual decision. NORI requests that the Chamber prescribe the following provisional measures. 1. Order the authority to immediately suspend the inquiry regarding the alleged possible non-compliance of NORI with its contractual obligations pending the final decision of the Chamber. 2. Order the authority to refrain from taking, authorising or permitting any further steps or measures in connection with that inquiry pending the final decision of the Chamber. 3. Order the authority to ensure that no recommendations, findings, reports or other outputs arising from the Commission's inquiry are adopted, issued, published, communicated or otherwise relied upon pending the final decision of the Chamber. 4. Pending the final decision of the Chamber, prohibit the authority from taking any step or adopting any position, including through the Commission, that would have the effect of prejudging, refusing, or otherwise adversely affecting NORI's application dated 19 January 2026 for an extension of the exploration contract, insofar as such action is based on or influenced by the ongoing inquiry. For the avoidance of doubt, this measure does not prevent the authority or the Commission from proceeding with consideration of that application in a lawful and impartial manner. 5. Prohibit the authority from taking any action that might aggravate or extend the dispute or prejudice the execution of any decision the Chamber may render. And finally, 6. Order such other provisional measures as the Chamber considers necessary to preserve NORI's rights and to ensure the effectiveness of its eventual decision. Mr. President, members of the Chamber, this concludes the applicant's submissions. The applicants thank the Chamber for its attention. The applicants also wish to thank the Registrar and all the staff of the Tribunal for organising these hearings with such efficiency. I thank you.
Thank you, Agent Eastwood. I now wish to declare that this concludes the second round of the applicant's oral arguments, as well as this morning's sitting. The hearing will resume this afternoon at 2 for the second round of oral arguments of the respondent. The sitting is now closed. Thank you.
All rise. Rise, veuillez vous lever.
Please be seated. Thank you. Good afternoon. The Seabed Disputes Chamber will continue its hearing in cases 34-35. This afternoon, the Chamber will hear the second round of the respondents' oral arguments. Before we begin, can I remind all speakers to speak at a measured pace to facilitate interpretation and preparation of the verbatim record. Thank you. I now give the floor to Mr. Reichhold to make his statement. You have the floor, sir.
President, members of the Chamber, in this second round of oral arguments, the authority will respond to the points raised by the applicants this morning. But we will only address those points that call for a response. And in light of the applicants' substantial narrowing of their requests, we can do so relatively quickly. We take this approach to assist the Chamber on the matters that remain before you and to avoid wasting the Chamber's time. I will address you on matters of fact. Professor Sands will deal with matters of law. And finally, the authority's agent, Mr. Dietrich, will come to the podium in order to give his closing remarks and read out the authority's final submissions. On the facts, the authority makes 9 points. First, yesterday and today, the applicants told you that they do not challenge the power of the authority, its council and the Commission to carry out this inquiry. That's what they said. Mr. Eastwood put it this way yesterday, and I quote, "The issue is not whether there should be an inquiry." This morning, Mr. Wordsworth said that the applicants are not challenging in any way the authority's undoubted power to ask questions. And Ms. Sander told you that at no point did the applicants challenge the authority's right to ask questions. Mr. President, with the greatest of respect to those on the other side, those submissions are, to put it politely, inaccurate. You will recall the Council's 2025 decision. That is the decision establishing and providing the mandate for this inquiry process. You were shown on the screens paragraphs 9 and 10 of the 2025 Council decision. The Secretary-General then sent a circular to all 21 contractors. The applicants both responded to that circular on the 9th of February 2026. And their responses, members of the Chamber, are at Annex 4 of NORI's written pleadings and Annex 3 to TOML's pleadings. What did the applicants actually say on the 9th of February? They said that the procedure set out in paragraphs 9 and 10 of the Council's decision, the process of seeking information, they said it is unlawful. There is only one logical conclusion that can be drawn from that inconsistency. Either what the applicants have said is not accurate, or their assertions on the legality set out in the 9th of February letter is just bluster, obfuscation, and a part of their litigation strategy. But they cannot both be true. Second, this morning, the applicants complained that the authority failed to address NORI's application to extend its contract, and in particular, the applicability, or rather non-applicability, of paragraph 16 of the Council's procedure and criteria for extension. They said, we have failed to address it in the first round. Again, that is not accurate. Professor Sands addressed paragraph 16 yesterday. Professor Sands said, and I quote directly from the official record of yesterday's session, he said, "It is the authority's position that this may not be correct." And he's referring here to the applicant's interpretation of paragraph 16. Professor Sands goes on. As NORI's contract is due to expire before, not after, the next scheduled meeting of the Legal and Technical Commission, as the language of paragraph 16 provides and makes clear, the provision existed for a different reason than the one we are now faced with. End of quote. Professor Sands then added that because the applicants raised paragraph 16 again in their first round of oral arguments yesterday, we will return to it in our second round today. There's nothing improper about that. And Mr. Dietrich will briefly address you on paragraph 16 and the extension application. The third point out of 9. You were told that the authority has refused to extend its deadline of the 31st of May for the applicants to respond to the questions that were put to them on the 16th of March. Again, that is not accurate. After consulting with the chair of the Commission, the authority's Secretary General wrote to the applicants on the 23rd of June this year and offered an extension. But in any event, it cannot be said to be unreasonable for the authority to impose a deadline of 2.5 months to answer 3 questions, particularly in circumstances where the Commission would need time to consider the information that they were obliged to provide, and that it had to do so for its session, which started on Monday this week. The fourth point, there is nothing to support the applicant's assertions that they are at imminent risk of the Commission reaching any final conclusions or recommendations in the current session that is taking place this week and next week. Paragraph 3 of the Council's 2026 decision, which is at Annex 6 of the authority's written response, states that the Council awaits the Commission's report during this current session. That is, members of the Chamber, a report on, and I'm quoting from the decision, it is a report on the ongoing requests for additional information. That's what the decision says, a report on the ongoing requests for additional information. It is not a report on the conclusions of an inquiry or on any final findings. And this is confirmed in the very next paragraph of the Council's 2026 decision, paragraph 4. What paragraph 4 says is, without imposing any deadline or any time frame, paragraph 4 says that the Council awaits the Commission's report and recommendations. And the distinction there is that it is not stated that recommendations are awaited in this session. There is a critical distinction between paragraphs 3 and paragraphs 4 of the 2026 decision. Mr. President, members of the Chamber, there is no fixed time frame for this inquiry. The applicants haven't shown you any document that sets out a time frame, in stark contrast to the other procedure, the general procedure on inadequate performance, and the slide that Ms. Jones showed you with the arrows over the course of a year. There is no such document for this inquiry. The inquiry that's been carried out under paragraphs 9 and 10 of the Council decision of 2025 will take as long as it takes. And the applicants will have the opportunity to feed into that process, and they will have an opportunity to be heard. That is what the Council has said in its decision of this year. The fifth point, you were told that the authority has not provided the applicants with any assurances. Again, that is not accurate. After receiving the applicant's long list of demands on the 21st and 22nd of April 2026, and you'll recall during my presentation yesterday, I put up on the screens that 4-page letter that sets out that long list of demands. Well, after those were received, the chair of the Commission wrote to the applicants and assured them that their concerns would be considered by the Commission fully and properly, and that the Commission was fully committed to discharge its responsibilities in accordance with its mandate. That is in accordance also with the Council's instruction to ensure due process. But the applicants were not satisfied by that assurance. And so less than 2 weeks later, the Secretary-General wrote to the applicants, and she assured them in writing that the Commission was evaluating their requests to determine how they could be accommodated. And she said that they were receiving thoughtful consideration, and she assured them, and I quote the Secretary-General, she said, "The authority is dedicated to the peaceful resolution of this matter and to fulfilling our responsibilities in good faith with full respect to the rights and obligations of all the parties under the Convention." But still, the applicants were not satisfied. Less than 2 weeks ago, the Secretary-General again assured the applicants that the authority was evaluating the extent to which their concerns could be accommodated. But still, the applicants were not satisfied. All of those assurances, Mr. President, members of the Chamber, all of those assurances are a matter of public record in these proceedings. Mr. Dietrich will return to this in due course. The sixth point out of 9. The applicants accuse the authority of refusing to engage with them and refusing to consult. Once again, that is not accurate. In her letter, the 23rd of June 2026, the Secretary-General invited the applicants to engage in consultations on Monday and Tuesday of this week. Of course, that consultation process cannot be done in parallel with this hearing in a contentious matter during the same week. Either the applicants should have accepted the authority's offer, made in good faith, to engage in meaningful consultations this week, or to continue with these inevitably ill-fated requests for provisional measures. But the applicants cannot have it both ways. They cannot have their cake and eat it too. Point 7. The applicants told you that yesterday is the first time that they began to find out about the authority's position on various aspects of the inquiry. Well, that flows inevitably from the fact that the applicants have decided to pursue this matter in litigation. Rather than doing what the authority would have preferred, which is by meaningful engagement and consultation. To put it very simply, Mr. President, members of the Chamber, we should not be here in Hamburg. The authority's legal team should be right now in Kingston, in Jamaica, at the seat of the authority, where the 31st session is currently underway, assisting the Commission with the issues raised by the applicants. But instead, because the applicants have trenchantly pursued these requests, here we are, engaged in litigation on matters that should properly be before the Commission in the first instance. Eighth, and relatedly, we listened with interest to the applicant's assertions about company structures, subsidiaries, parent companies, directors, the principle of the corporate veil. And we heard the applicant say that none of the directors of NORI and TOML are directors of the Metals Company USA. Mr. President, those are all points that the applicant should have made, and indeed should make, to the Commission. We've never heard those points before, because they refuse to answer the questions and they refuse to engage meaningfully with the early stages of information gathering that the Commission is undertaking. It's for the Commission, in the first instance, to shape the scope of its inquiry, to determine how and to what extent the applicant's so-called due process concerns can be accommodated, and consider the information provided. And with all due respect, it is not for the Chamber to conduct this inquiry on the Commission's behalf. Mr. President, members of the Chamber, I listened with interest also to Mr. Orhi's reference to the judicial review process in English domestic law. Now, putting aside whether it is appropriate to compare that process with what we're doing here, what I can tell you is that in a judicial review process, you have to judicially review a decision or something that has happened. But what's happened in this case is the applicants have come to you before anything has been done, before a decision. The only thing that has happened is that 3 questions were sent by letter to the applicants. And you are asked to treat this as some form of final decision and to then dictate precisely how and in what way and on what timeframes the Commission should go on to carry out the process. That would be completely inappropriate and wrong as a matter of domestic law, just as it is completely inappropriate and wrong as a matter of international law. That's why we say that fundamentally these requests are premature. They shouldn't have been made. The 9th and final point. Ms. Sander referred to the potential serious consequences that might arise at the end of the inquiry process. As I already explained, we are a long way off. The authority is a long way off from the end of an inquiry process. But I will respond to the point made by Ms. Sander in relation to the serious consequences and penalties that she said could arise. Well, actually, Section 21 of the applicant's contracts, and these are in Annex 1 of the NORI pleadings and Annex 1 of the TOML pleadings. If you look at their contracts, Section 21, it contains specific procedural safeguards. Clause 21.2, for example, sets out a process in the contract by which the authority has to provide a statement of reasons, and the contractor has 60 days to respond. And it makes sense for that process to be in Section 21, because that's dealing with a sanction or a penalty. Section 21 therefore protects contractors' rights to exhaust judicial remedies, including coming to this chamber. So what arises from that is that where the drafters, bearing in mind the standard clauses in those contracts, come from and emanate from regulations, where the drafters intended for there to be a specific procedure or a specific safeguard, they are set out in the contract. The authority has, and it will, comply with those requirements, But as I have said, this inquiry, the end point of this inquiry is a long way off. No facts have been established, no recommendations have been made, and no decisions have been taken. So it is completely premature and hypothetical for anyone to address you on serious consequences or penalties, because nothing has been decided. In conclusion, Mr. President, members of the Chamber, that is why we say this case is wholly premature, and there was no reasonable or justifiable basis for bringing these requests. Mr. President, that concludes my presentation on the facts, and I would respectfully invite you to ask Professor Sands to come to this podium.
Thank you, Mr. Reichhold. I now give the floor to Professor Sands. You have the floor, sir.
Mr. President, members of the Chamber, we've heard from the applicants on the facts, and we've heard from the applicants on the law, and it's possible that a bit like us, you understand that feeling of being bombarded by a farrago of legal arguments, almost as though you were in a commercial court in London, or an investor-state arbitration, or transported back to Charles Dickens' London and appearing in some pages of Bleak House. We even heard counsel this morning make a plea for an opportunity for the applicants to make a post-hearing written submission. This never ends. They want special treatment, just as they did in response to the questions put to them by the LTC. Whether it's the regulator or whether it's this chamber, they will never give up. They will never stop. The opportunities given to them are somehow never enough. Their rights will never be respected. That is the position that they take. Not only do they want to have the first word in the proceedings, they also want to have the last word in these proceedings. Welcome to the world of strategic commercial litigation. Welcome to what is coming next, if this case ever actually proceeds to the merits. Well, we trust the Chamber will now shortly bring these proceedings to a close. There is no justification or need for any post-hearing briefs. I'm going to address the legal arguments, and I'm going to do so very briefly, as there really isn't much to add. These points are in response to what we heard this morning. Before I do so, can I just respond to the submissions made yesterday on behalf of Nauru by the Vice President, to whom we listened with great respect. Yesterday I took you to the application made by the Metals Company USA to the US National Oceanic and Atmospheric Administration. I showed you sections 4.5.5 and 4.5.6 of this document. Those are the sections which outline the details of an updated sponsorship agreement between Nauru and NORI. That agreement is available. It's in full, publicly online for all to see, and our colleagues and friends from Nauru were here in the room. Did they address any of this yesterday? I want to draw your attention in particular to clauses 23.3 and 4 of this agreement, which provides as follows. 23.3. This clause applies if and only if all of the following conditions have been fulfilled. A subsidiary of the metals company other than NORI obtains a permit, license, or other authorization from the US for the conduct of deep seabed mineral activities. And B, that TMC subsidiary commences commercial recovery activities of deep seabed minerals pursuant to that permit, license, or other authorization. And then 23.4. Upon signing of this agreement, and in any event within X business days thereafter, TMC will issue the Republic, Nauru, a warrant to purchase common shares of TMC representing X in substantially the form of Exhibit A attached to this agreement. The initial exercise price of the warrant will equal the closing price of TMC's common shares on the Nasdaq stock market, etc., etc. The obligations of TMC with respect to the issuance of these warrants are further set forth in the deed of guarantee and indemnity executed by TMC and the Republic in connection with this agreement. Now, these clauses are publicly available. We listened to the distinguished Vice President yesterday speak to you about the virtues of transparency. But the question arises, Mr. President, does Nauru practice what it preaches? Has Nauru engaged with the authority in any way to say anything or explain anything about this agreement with NOAA? As far as we're aware, it has not. Did Nauru yesterday care to explain how this clause and agreement, which gives that country a financial interest in deep sea mining carried on outside the multilateral framework, how that can be reconciled with their obligations under Article 137? They did not. Has Nauru made this agreement available on its own government website in the interests of the transparency to which it says it is so deeply committed? Well, we found one mention of it on the website, but if the text is available on the government website, we certainly haven't been able to find it. And so, with the greatest possible respect, we say that Nauru is perhaps not best placed to offer lessons to the authority on matters of transparency. So let me turn to a second point, what this case is really about. You will have noted, as we have, that the applicant's case has shifted very significantly over the last 48 hours. It is something of a moving target for us, as it may be for you. It appears now to be reduced to a single concern and claim. Much has been ditched. Perhaps as the composition of the legal team has evolved, so have the arguments. What is that single concern and claim? I take the words as I heard them, spoken by Mr. Wordsworth this morning, Mr. Orhi, and the agent then effectively repeated them. We don't have the official transcripts, I'm afraid. With respect, if I've made any error in it, we will have to correct it once we've seen the final transcript. We want to avoid final recommendations without the applicants being afforded due process. I'm going to read those words again. That's the applicant's position this morning. Their only claim. We want to avoid final recommendations without the applicants being afforded due process. There are two key words here. Final recommendation. That's the only issue that is now before this chamber. The final recommendation from the LTC to the Council. It's to be noted that anything the Commission does is in any event in relation to the Council to be only advisory in nature. The Council would then have to act on such recommendations if it wished to do, and of course it may not. And that's why we've said all along, there is no chance, zero chance, of the rights of the applicants being affected by what is going on in terms of this inquiry. Until that happens, in relation to action by the Council. Now, this change of position by the applicants is very significant indeed. Bad faith, discrimination, ultra vires, and so on and so forth, they've all gone, disappeared from the case. We're left with due process, but only in respect of the final recommendation. And that shift of position is significant because it confirms the prematurity of this case. Because the process of an inquiry has only just begun. And we are some ways off, a long way off perhaps, from any final recommendation to the Council, as Mr. Reichold explained. So if we've understood correctly, Mr. Wordsworth has in effect confirmed that the applicants have no objection to the LTC making recommendations that are not final. For example, on the procedure that is to be followed in the inquiry. Given this approach, we can see no basis at all for the continuation of the Article 90 measure, which was imposed on Monday, and the agent will say more about this shortly. And that, of course, would allow consideration of NORI's application for extension of its exploration licence to proceed pretty much immediately during this session of the LTC, which is something that the authority supports, but is not able to do. The authority has made clear in relation to due process rights that it will continue to fully respect them. There are many steps to be followed by the Commission. One could imagine what those steps might be. Some of you have been on the Commission. You know how it functions. I haven't. At some point, perhaps, the applicants would choose to answer the 3 questions put to them by the Commission in the manner they consider to be appropriate. They could be short answers, they could be long answers, who knows what the answers would be. And thereafter, the Commission may wish to consider those responses and form a view as to whether they meet what they hope for or not. And the Commission might then follow up. And one could then imagine exchanges between the Commission and the applicants. And the applicants themselves may then seek clarifications and put some of the points that they've addressed in the course of this hearing to the Commission. And presumably the Commission would engage and seek or not offer to give some of those clarifications. And one can imagine, as with any inquiry in any process and any case like this case, that the points in issue are going to narrow down between the parties. And then there might be further exchanges. And then at some point later on, the Commission would prepare its final recommendation. Or it might even decide, given what it's heard, that there's no recommendation that needs to be made. All of that is unknown, but it's a long way off. So, Mr. President and members of the Chamber, against this background and Mr. Wordsworth's characterisation of what the applicants say they want, is there even any need for the Chamber to prescribe any provisional measures? We say there isn't. And you're going to hear shortly from the authority's agent on this issue. He will offer an undertaking on due process, one that takes forward, based on the commitments that have already expressed, but does so in this most solemn of places. And with such an undertaking, we say there's no need for the Chamber to order a provisional measure. It can simply dispense with the matter by accepting, recognising that undertaking on its face. And of course, if in due course, as the Commission conducts its inquiry, the applicants consider that the undertaking given by the agent has not been met, they'll be free to come back to this chamber to address the issue. And so for that reason alone, we say you don't even have to decide on any of the legal issues, because there is no basis for a provisional measure to be indicated in those circumstances. Which brings me to a third point. If the chamber decides, nevertheless, that it does have to decide on the legal issues, the authority reiterates its view that there is no conceivable basis under the Convention for it to do so. The conditions are cumulative, and we say none of them have been met. On Article 187, we have nothing to add to what was said yesterday. We heard nothing new today. Article 187 offers no basis to order a provisional measure to the effect that the authority shall ensure that before the LTC makes final recommendations on the inquiry, the applicants shall be afforded due process. Makes no sense to order such a provisional measure when the agent has given you an undertaking. On Article 189, we also have nothing further to add to what was said yesterday. There is no new argument that we're making, and I apologise if Mr. Ori didn't understand quite what I said yesterday. I'm sure the fault is mine. It was merely that we were intending to take the chamber to the document that the applicants had put in the judge's folder yesterday, but it came late for us and we didn't have time to do it. And that document was helpful to us, and we think to the chamber, because it emphasises how Article 189 cuts in and precludes this chamber from having or exercising jurisdiction. For any tribunal, you follow the path of least resistance. We say there's no need to give any provisional measure in light of what's happened over the last couple of days. But if you have to address the legal arguments, the easiest way to get rid of this case is Article 189, because plainly it cuts in and prevents this application from being made. The application has no legs. You can see on the screen here one of the original drafts of Article 191. This is taken from the document that was put in yesterday by the applicants. And as the Virginia commentary states, volume 6, pages 634 to 5, and I quote, "There was a clear shift designed to protect the Assembly and the Council against too much interference by the Chamber." And this is pretty early in the final negotiations. But then there was a further change as draft Article 191 became draft Article 190. And the words scope of jurisdiction were changed to limitation on jurisdiction. And as you can see, if you read to the bottom of the text, you'll see the chair of the legal group of experts explained that the change is intended to show that the provision, and I quote, clearly restrains the chamber from questioning the discretionary power of the authority. Negotiating history is really very clear, and with great respect to our friends on the other side, we really haven't heard any plausible argument as to how it could be said that the authority's compliance functions are anything other than a discretionary power. The decision to issue a letter is par excellence an exercise in discretionary power. The applicants have simply not explained why the process followed by the authority, sending 3 questions to the applicants, should not be treated as an exercise of discretionary power. On the plausibility of rights, we've got nothing further to add from yesterday. It is manifest to us that any provisional application before an international court or tribunal has to form a view as to whether the existence of the rights is plausible, and that includes some sort of a finding as to whether a violation of those rights is plausible. If you want a recent discussion on that, you might look to the dissenting opinion of Judge Youssef in a recent case of Equatorial Guinea and France. dissented because that was exactly what he says the International Court of Justice did. They looked at whether there was any plausible violation of the rights. And he writes that precedents have moved towards an approach involving a limited review on the substance of the case. And he cites various judgments, including Ukraine versus Russian Federation, Provisional Measures Order of 19th of April 2017, where, as Judge Youssef puts it, the court held that it must ascertain whether there are sufficient reasons for considering that certain elements, such as intent or knowledge, are present in order to determine whether the rights for which Ukraine seeks protection are at least plausible, and found that at this stage of the proceedings, the court concluded that Ukraine has not put before the court evidence which affords a sufficient basis to find it plausible that these elements are present. Is it plausible at this stage that there's been a violation of the due process rights? It is not plausible. But in any event, you don't need to enter into that debate, however interesting it may be. The rights, we say, that are invoked are not plausible. And relatedly, on the applicant's revised and very narrow and limited case, we say it cannot seriously be argued, it cannot be argued at all, even not seriously, that there is any urgency or risk of irreparable harm in relation to any such rights, even assuming to be plausible, in circumstances in which the applicants have now told you that their concern is limited to the Commission making final recommendations on the inquiry without the applicants having been afforded due process. How can they stand before you and say that there is urgency in relation to that situation? I'm sorry, it is a hopeless, hopeless argument. In any event, as you will hear further, the authority has undertaken to respect those due process rights and to do so very fully and completely. And you're going to hear shortly from the agent on this point. Mr. President, members of the Chamber, I've been very brief because the issues at this stage of the proceedings really are very narrowly focused. And we say with great frankness that they are clear and straightforward and as simple as they get. This case is an artifice. It is a constructed case. It is a constructed dispute. The applicants have simply chosen not to respond to the Commission's 3 questions. They could have offered a response to the best of their abilities. It may have been a limited response, and the Commission would no doubt then have engaged in exchanges to tease out the issue. This is what happens every hour and every day all over the world, at the national level and at the international level. This is the key point. The record before you shows there is no dispute between the parties. There's no dispute between the parties. The applicants have now told you what they want is to avoid the LTC making final recommendations to the Council without having been afforded due process. That is an entirely reasonable want. We don't challenge that want in any way at all. In fact, we, the authority, have said we want that want to be respected and fully respected, and we will fully respect it. Against that background, what is the dispute between the parties? Where is the dispute? Why are we here? What is the need for provisional measures? Mr. President, members of the Chamber, thank you for your attention, and I invite you now to give the floor to the distinguished agent of the authority.
Thank you, Professor Sens, for your statement. I now invite the agent of the authority, Mr. Dittrich, to make his closing remarks and present the final submissions of the respondent. May I again recall that pursuant to Article 75, Para 2 of the Rules of the Tribunal, at the conclusion of the last statement made by a party at the hearing, its agent, without recapitulation of the arguments, shall read that party's final submissions. A copy of the written text of these, signed by the agent, shall be communicated to the Chamber and transmitted to the other party. I now have the honor to invite the agent of the authority to make his statement and present the final submissions. Thank you. You have the floor, sir.
Thank you, Mr. President. I return to address two important matters raised by the applicants and to make the authority's final submissions. Firstly, the agent for the applicants has characterized this case as one concerning due process in relation to any final recommendations to be made by the Commission. However, I must respectfully clarify that this characterization does not reflect the circumstances. The authority has consistently communicated that the applicant's due process rights have been fully respected throughout this process, and we will continue to honor these rights. This assurance has been made publicly and remains on record. There is no doubt regarding our commitment in this regard. On behalf of the authority, I would like to reiterate those assurances today, both on record and as a formal undertaking to the Chamber on the record. The authority is dedicated to upholding all of its obligations to the applicants during the inquiry process, which it is mandated to conduct as a responsible regulator. Therefore, I submit that there is no necessity for provisional measures concerning due process or any other matters. As Professor Sands has said, it is not even apparent to us that any dispute exists between the parties. The applicants want the authority to respect their due process rights in the inquiry, and the authority has confirmed that it will fully respect those due process rights. The second point I wish to address pertains to NORI's application to extend its contract. It is indeed regrettable that NORI finds itself in this challenging situation. Earlier this week, we observed that the applicants renewed their request for the President to exercise his powers under Article 90, subsection 4 of the Tribunal's rules. Shortly thereafter, we received a letter from the Registrar where the President called upon the parties to refrain from taking any actions that might impede the orders of the Seabed Disputes Chamber. This directive was unexpected for the authority, especially given that we were on the verge of informing the Chamber, as it knew, of which such order may not be warranted and all of the potential complications it could incur. Nonetheless, the authority has shown utmost respect for the Chamber's directives and has acted in accordance with the rule of law and in good faith. The Commission has suspended its consideration of matters related to the applicant's claims and requests, including the preliminary stage of the inquiry process and NORI's application for extension. This suspension was necessary due to the broad scope of the Chamber's directive, which required us not to take actions that could hinder your decisions. Adhering to judicial instructions, the authority has paused all activities within the Commission's purview of the applicant's claims. In due course, NORI recognized the implications of its litigation strategy and invoked paragraph 16 of the annex to the authority's procedures and criteria. However, as explained by Professor Sands yesterday, and addressed again by my colleague Mr. Reichhold today, this paragraph addresses a specific scenario. The applicant had this point overnight. There is no justification for any further submissions on this issue. To clarify once again, Mr. President, members of the Chamber, NORI's application for contract extension must first be evaluated by the Commission. Unless this evaluation takes place before Friday of next week, NORI's contract will expire on the 22nd of July 2026. The authority has assured NORI that its extension application will be processed fairly and lawfully, in accordance with the Council's procedures and criteria for extension. I would like to emphasize here that the consideration of NORI's extension application is entirely separate from the processes linked to paragraphs 9 and 10 of the 2025 Council decision. The authority's assurances regarding NORI's extension application are publicly documented in paragraph 79 of the authority's written pleadings. I want to reiterate this commitment today as a formal undertaking to the Chamber. In light of this discussion, let me be clear. There is no need for the Chamber to impose any provisional measures. You have reviewed the Council's decisions, noted the authority's written assurances, and listened to the reaffirmations I have made here today. It is open to you to record these undertakings into the forthcoming order. There appears to be no valid justification for the requests presented, notably the evident lack of prima facie jurisdiction under Article 189, the absence of any plausible rights that are at risk of violation, and a lack of evidence suggesting a threat of irreparable harm. Finally, in order for the authority to carry out its powers and functions under the Convention and the 94 Agreement, including lawfully considering NORI's extension application before its contract expires, we invite the Chamber, as a matter of urgency, and in any event before Monday of next week, while the Commission is still in session, to withdraw the measure adopted under Article 94 of the Tribunal's rules. This will allow the Commission to proceed with its work. We understand that at the time it was handed down, the full facts may not have been available to the President, but now they are. And in light of the undertakings I have given, we hope each of you can see that it's perfectly clear that there's absolutely no need for any Article 90 measure. And that its continuation causes practical difficulties for the authority and its organs, and also for the applicants in relation to the extension of its exploration contract. Mr. President and members of the Chamber, the authority truly appreciates your attention to these matters and trust that they will inform your decision-making process. I conclude by thanking you, Mr. President, esteemed members of the Chamber, the Registrar and her excellent staff, and the work of the translators. We are grateful for your attention and the exemplary work that has gone into arranging these hearings on such short notice. I will conclude with the authority's final submissions in these proceedings. For reasons set out in the authority's statement of the 25th of June 2026 and elaborated upon at the present hearing, the authority respectfully requests the Seabed Disputes Chamber to reject all of the requests made by NORI and TOML for the prescription of provisional measures, to withdraw the direction made by the President of the Chamber pursuant to Article 94 of the Tribunal's rules before 9 a.m. Kingston time, Monday, the 6th of July, and to order NORI and TOML to bear in equal share the authority's costs of responding to their requests for the prescription of provisional measures and attending these hearings in Hamburg on the 2nd and 3rd of July, 2026. Thank you.
We have now reached the end of the hearing. On behalf of the Chamber, I would like to take this opportunity to express our appreciation for the high quality of the presentations made during the hearing. I would also like to thank the agents of the parties for their spirit of cooperation. I now call on the Registrar to address questions in relation to the documentation. Thank you.
Mr. President, pursuant to Article 86, paragraph 4 of the Rules of the Tribunal, the parties may, under the supervision of the Seabed Disputes Chamber, correct the transcripts of speeches and statements made on their behalf, but in no case may such corrections affect the meaning and scope thereof. These corrections relate to the transcripts in the official language used by the party in question. The parties are requested to use for this purpose the verified versions of the transcripts and not those marked as unchecked. The corrections should be submitted to the registry as soon as possible and by Tuesday, 7 July 2026 at 4 p.m. Hamburg time at the latest. The representative of the Republic of Nauru is also requested to submit any corrections to the transcript of the sponsoring state's oral statement to the registry within the same time limit. Mr. President.
Thank you. The Chamber will now withdraw to deliberate. The date for the reading of the order in this case is tentatively set to Saturday, 18 July 2026 at 3 p.m. However, the agents will be informed reasonably well in advance of any change, The representative of the Republic of Nauru will also be informed. In accordance with the usual practice, and particularly in this case, I request the agents of the parties to kindly remain at the disposal of the Chamber in order to provide any further assistance and information that it may need in its deliberations. The hearing is now closed. Thank you.
All rise.